Good morning. This is Judge Elisa Perez presiding over the 210th District Court civil docket for May 1st, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings, as well as being streamed live via YouTube for public viewing. Mr. Monares, would you call our first case, please?
Calling cause number 2023 DCV 1391, Ricardo Legarda and George Martinez versus Miguel Ángel Lopez Hernandez et al. May I have announcements, please?
Yes, John Duff on behalf of the plaintiffs, and I believe my co-counsel should be joining us or might be in the waiting room, Eric Meza.
And Your Honor, I'm sorry, go ahead.
No, I was just letting him in. Go ahead, Mr. Almanzan.
Thank you, Your Honor. And this is Andrés Almanzan on behalf of Defendant Servicio Internacional de Enlace Terrestre SADCB DBA Transportes 7.
And I'm assuming that's Mr. Mesa. Mr. Mesa, are you there? I see his firm there, but I'm...
Yes, Judge, I apologize. I'm using my phone and I'm in my car, but yes, I'm here.
So we're here for a status conference. Is this the one where we still have the driver outstanding?
Yes,
Your Honor, it is.
How are we doing, Mr. Duff or Mr. Mesa, whoever?
So we filed an affidavit with the court yesterday. Our process server has been out several times to this location where he was last known to be. We are still unable to get him served at this time. So, I mean, with the affidavit we have, there's been almost a dozen attempts to be made. The process server does say that the last known residence does appear to be vacated. In my understanding that it looks like there's some stuff there, but not a whole lot of stuff at this location. So I don't think the court would be inclined to grant a motion for substitute service on that location because I don't believe we can reasonably tell that he is there, has been there recently. I would like to move this case along, however, and so I know the other defendant company has a motion to bifurcate this case. I don't know if we want to take that up at another date or not, but I would like to start doing discovery with the defendant company just so we can move this case along and get it off your docket.
Okay, so I'm just looking at that affidavit now. Mr. Almanzan, let me hear from you.
Yes, Your Honor, I received the affidavit yesterday, as did the court. I understand the process server's efforts and that he has not been able to find Mr. Lopez Hernandez, and that now apparently, according to the process server, the residence appears to be vacated. So, unfortunately, it doesn't look like he even lives there anymore. Your Honor, we don't have an objection to conducting discovery with respect to the company and the plaintiffs. But obviously, we're at a little bit of a disadvantage in terms of entering a scheduling order at this point without all the parties before the court. So, in other words, I'm looking for a compromise. Obviously, we can do what we can do without the driver, and there's plenty we can do without the driver. But there are certain aspects of the case that we would be at a disadvantage if we don't have the driver before us.
All right. That motion to bifurcate was filed back in November. I have to assume that was somewhat of the reason was because we had some indicators that maybe driver wouldn't be located. Is that basically what we're talking about? And am I hearing you, Mr. Duff, to say that you're in agreement with the defendant's request?
Well,
okay, thank you, Mr. Duff. Your Honor, it's not necessarily a bifurcation of parties. It's just standard bifurcation of certain damages and trucking, basically related bifurcation according to the Civil Practice and Remedies Code, Your Honor.
Got it.
Which again, we can schedule to be heard without necessarily already having served the driver. That is an issue that I think is ripe for the court to hear. And we're happy to schedule that at this time, or whenever the court wishes to.
All righty. All right, Mr. Duff, what are you asking me for?
I'm really asking if we can start doing some discovery with our defendant company. Our process server, I mean, he's still working, reaching out to his contacts out in Juarez and trying to figure out where he can locate this gentleman at. I just have a feeling that he's in the wind and we probably will never hear from him or see him again. So I would like to figure out a way where we can move this case along, let us start doing some discovery. If that does require getting the defendant driver into another cause of action while we have the defendant company still in this cause of action, I guess that's what I would request at this time, just so we can move this case along.
Right. So we've been set for scheduling status conferences before. And you know, if this had been a first stab at scheduling, I would put you a year out, and you probably still need a year out. Because things really haven't moved. That puts us into May of 2025 in terms of a trial date. So I would look at May 2nd, 2025 with an April 30th docket call. It's just kind of scary for me to schedule so far out, but it is what it is.
And Your Honor, before we filed the case, and we filed pretty close to statute of limitations, I know there were some ongoing negotiations, so maybe a couple depositions might help move that along as well.
Okay. Well, of course, there will be a deadline for mediation. It's still closer to the trial date, some 30 odd days before your docket call. We'll get to the schedule. We'll get you the scheduling order, have it returned, and do what you can. We'll just go from there. Anything outside of those dates, if they something requires a hearing, please email your file stamp leading to Ms. Hernandez, and we'll get you scheduled.
Okay.
All righty.
Sounds
Thank
good.
you very much.
Coordinate with your coordinator, Your Honor, to request available dates for the motion to bifurcate. And of
Yes.
course, pass along those dates to Mr. Duff and Mr. Mesa to make sure they're available.
Yes, sir. Thank you.
All right. Thank you, everyone.
Thank
Have
you.
a good day.
Take care.
Bye.
Thank you, Judge.
Okay, Judge, page 1, also 1848.
Mhm. All right. Is that Mr. Rutledge? Okay, go ahead, Mr. Monares.
Calling cause number 2023 DCV 1848. Velocity Investments LLC versus Felix Cash Lopez. May I have announcements, please?
David Rutledge for the plaintiff, we're ready.
Mr. Cimental, is this your case?
Correct, yes. We're ready to set the case for trial.
May I have announcements, sir?
No announcements. We received the documents at this time from opposing counsel, so if you guys would like to set the case for trial.
I thought this was a trial.
So the only notation, Mr. Rutledge, do you have a camera, a working camera?
I thought I did.
Can you turn on your video, please? So the notation I have, we are set for a scheduling status conference. The only notation I have here is that you all are requesting a bench trial date. Is that correct?
Correct for the defense.
Okay.
There you go.
I
Now
mean,
I'm
is it ready to go, or do you need, I don't know if a scheduling, there's not been any type of scheduling order. I don't know what type of discovery you've done. All I see is a petition filed in June, some substituted service in September, an appearance, business record affidavit, a scheduling status conference, entry of appearance in January. So when do you want your bench trial, and what do you need in anticipation of that?
For us, probably for defense, probably just about 30 days. We received informal discovery, so we received the business record affidavit. So we just need to review it and then get back to our client on an offer.
Mr. Rutledge?
We're ready.
We can do June 12th at 1:30.
Okay. Sounds good to me. May
Are
not
we
be,
doing this in person or via Zoom?
doesn't matter to me, Judge.
Mr. Cimental?
Via Zoom preferably.
Okay, we'll have that set.
Thank
We'll
you, Your
see
Honor.
you then. Thank you for your time.
Thank
Thank
you.
you. May I be excused, Judge?
Okay, have a good day. Who's
You
next?
too. Thank you.
Judge, let me bring in Mr. Raymond Baeza. He was the case that was rescheduled, just so we can let him know. Morning, Mr. Baeza.
Yes, sir. Good morning.
Good morning, Mr. Morga and Mr. Garcia appeared earlier. They wanted your case rescheduled for a different date. So
Perfect. I just wanted to
no,
make sure I didn't miss it. I saw an email, but I thought, you know what, let me appear just to make sure that they didn't have the hearing.
okay. Thank you, sir.
Thank you so much. I appreciate it. Have a good day.
Okay, Judge, page 20053.
Okay. Mr. Bettis and Mr. Newton, are you there?
Good
This
morning,
is-
Your Honor.
This is for real this time. Go ahead, Mr. Newton, are you there?
Mr. Newton?
He may have stepped away.
Mr. Newton?
Okay,
Well,
well,
we
I
can move on
jinxed
to
it.
another one.
Yeah,
I'll put you back in the waiting room, sir.
All right, sounds good.
Thirteen 35, Judge.
mm-hmm.
Oh,
Good morning, council. Go ahead, Mr. Morales.
calling cause number 2023 DCV 1335, Pedro Morales versus Copestone General Contractors et al. May I have announcements, please?
Good morning, Your Honor. Alejandro Acosta for the plaintiff.
Good morning.
Katie Spring for Defendant, Martinez Brothers Contracting.
Good morning, Your Honor and Counsel. Nicholas Sinak appearing for Copestone General Contractors.
All righty. Except for scheduling a status conference, do we still have Carter Globe Associates outstanding or no?
They are still outstanding. I don't believe they've entered appearance. I don't anticipate they will, and I don't think they'll be in the lawsuit much longer.
Okay.
As you know, this case was remanded back from Judge Briones. There's still two defendants that are in the process of being served. I think we'll have them served in the next week or so. And so I would recommend maybe setting another status conference, another 60 days. And I think at that time we could probably set a trial date and enter a scheduling order once everybody's in the case.
All righty. Another 60 days. All right. Are you all in agreement with that?
No objections.
All
Yes,
right. We'll come back in 60 days. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day. Bye-bye.
You too.
0117, Judge, at the end of the page. Calling cause number 2024 DCV 0117, U.S. Bank Trust National Association et al. Versus Isidra Pineda Gatewood and occupants of the property. May I have announcements?
Yes, George Shears appearing for U.S. Bank today.
Good morning, sir.
Good morning.
Bear with me. Let me review a few things here. We're set
Okay.
on an, let's see, it says foreclosure, default hearing. Give me 1 second. Has there been any contact with Isidra Pineda Gatewood?
There has been correspondence mailed to her at the last known address, which is the property address, and there's been no response.
Was there an attempt to send notice regarding today's hearing?
No, Your Honor, we have not sent notice of that. There's been no response filed, so this, yeah, was set as a default hearing under the rules.
Okay. So in terms of the default, generally, I understand that obviously sometimes part of the problem is, having a good contact, but I do ask that we make an attempt to provide the individual notice of the hearing. So what I am going to do is, we set this back in April. So that's around the timetable I would ask that we give the individual or anyone to come forward. So you can anticipate a reset of 30 days.
Okay.
If you will get, so that will put us at June 5th, 10 a.m. Frankly, as long as you send some type of notice and some type of verifiable, even if it's a green card gets returned, not able to deliver, whatever it is, that should give you plenty of time to get that back. I will also encourage you that if you get it back quicker than the 30 days, if you will email it to the court coordinator as kind of an addendum or an exhibit or an attachment for the court. Frankly, if I have that ahead of time, I call this case in 30 days and should be on track.
Get the zoning Wednesday. Okay, so June 5th at 10 a.m. Okay, yes, we'll send out notice of a hearing, reset hearing, and we'll send it to her first class mail and send it out. See if we
Thank
get
you
a
very much.
response. Okay, thank you, Your Honor.
Have a good day.
Thank you.
Okay, next.
Let me identify this user, Judge.
Okay.
Good morning, BWW admin. Borland Wall.
Mute. Okay.
Yes, which case number are you?
Okay.
Here?
I'm sorry. This is Jay Newton. I was on that other case.
Jay Newton. Okay.
And I tried to get on whenever the judge came on. I tried to click on my video and unmute myself, and it wouldn't let me. I don't.
Okay.
Probably something on my end. I just don't know what's going on. But I was there, so.
We believe you. We believe you.
I was even trying to type a message, and it wouldn't let me do that. So.
Call it.
Calling cause number 2024 DCV 0053, Desert Peaks LLC versus the JL Gray Company et al. May I have announcements, please?
This is Jay Newton for the plaintiff, Desert Peaks LLC.
Good morning, Your Honor. Gabriel Pettis on behalf of defendant, Blacktop Bros Incorporated.
Good morning. So we're here for scheduling status conference. Do you all need a trial date now?
The weird thing about this case, Judge, is that we're still trying to get one of the parties joined. We had to serve via substitute service on Secretary of State. They actually have an attorney who I've been dealing with, but he's not authorized to accept service. So I'm having difficulties, but we finally have something in place that should work.
Can we figure something out in 30 days or do you need more time than that?
Well, that's a good question. I know it always takes a while when we have to do it this way. maybe a little more time. I'm sorry.
Okay. Well, since you're sorry, we'll give you 60 days. Mr. Pettis. Just
Appreciate that.
know, the more we push this back, the later I'm going to get you scheduled for trial. But it's a 2024 case, so you might still be on track. All right, so we'll come back in 60 days. Thank you, gentlemen, for your time. All right.
Thank you so much.
Take care. Who's next?
Give me 1 second, Judge. Myrna, on page 3, the top of the page, that one was reset, right?
I show the motion to compel being canceled.
Okay, let me bring out Ms. Cedillo in so we let her know. Morning, Ms. Cedillo. Good morning, Ms. Cedillo.
Yes.
Hi, the motion to compel was canceled, ma'am.
I am so sorry. I was not aware of that.
No
And I was
problem.
gonna let the court know that we're already looking for a mediator. But we're gonna go out of area since we need Spanish speaker, and we should hopefully have mediation scheduled in July or August.
Okay,
The parties tried, couldn't.
okay.
But I am so sorry. I was not aware of that.
Oh, no problem. Thank you.
Thank you for your time.
Morning, Mrs. Barca. Okay, Judge, page 3, 3903.
All righty. Hey, Mr. Martinez.
Good morning, Your Honor. How are you doing this morning?
I'm all right. How are you?
Cannot complain.
So who's here, Ms. Stronghill? Go ahead. Is everybody here? Okay, go ahead and call it. Sure.
Calling cause number 2023 DCV 3903. Elizabeth Quintana et al. Versus Pantusa Towing and Recovery LLC et al. May I have announcements, please?
Ivan Martinez for the City of El Paso.
Lainey Piercy for the plaintiffs.
Carolyn Ronhell for defendants.
Okay. Is Mr. Biganowski in? Or who is this? Are people just coming?
Yeah, Judge, there are several interveners in this case as well, and I don't see, oh yeah, well, I don't see all of them, but.
Well, let's
okay.
see who else pops into the session, and then we'll start asking questions.
Okay.
Thank you. Okay, is everyone on the screen here for 2023 DCV 3903? Yes, Mr. Buss, I see your cause number. Mr. Biganowski, are you here on that cause number as well?
I believe so. If that's I can't think of the style of the case, Your Honor. But there should be like 6. Yes.
Okay.
Yes, Your Honor.
Mr. Ruman, that's you as well?
Yes, ma'am.
Okay. All righty. So let me get some announcements if I haven't already.
For Charles Gardner, Victor Biganowski, plaintiff, Your Honor.
Jonathan Baeza for Ms. Lavinati on behalf of intervener plaintiff Martin Torres.
Charles Rimmon on behalf of intervener Omar Roquillo.
What is that, Ronquillo? Is
Yes.
that? Okay, is that everybody now? All righty. Okay, good morning, everyone. We are set for a status conference in this case. Who's going to start off?
Yes, Your Honor. Thank you. I had requested this hearing. The parties had requested a hold be placed on the vehicles that were involved, I guess, as part of this civil case. And at the time, there was a criminal investigation taking place with the El Paso Police Department. So the El Paso Police Department also had a hold, a law enforcement hold on these vehicles. So what I had agreed to was back in January, and you had signed off on it, basically a court order that the police department hold on to these vehicles, not release them, and work with the attorneys, the civil attorneys, to try and allow inspections of the vehicles. And this was an order that you had signed on January 31st, I believe. So what's happened was, and this is kind of a twist, is that on March 14th, the police department concluded their investigation and determined that, in fact, a crime had not taken place. They consulted with the district attorney's office and decided that there was nothing to charge. There's no criminal case pending. So the police department requested a release of the vehicles back on March 14th. So that's kind of the predicament we're in, Your Honor, is that this order that you had signed in January assumes that and rightfully so, because it was true at the time, was that the El Paso Police Department would assist in the inspection and transportation of these vehicles if needed. But what's happened is since March 14th, the police department is no longer paying for the storage of these vehicles. The way it's been working since March 14th is fees have been accumulating for the storage of these vehicles. And so that the storage fees for each vehicle as of today is about $1,000, and there's a Peterbilt a truck that's $2,000 since it's bigger. So that's one issue that kind of needs to be resolved, is the costs and the payments for these storage fees for these vehicles and who's going to pay for those. But that's just a sub issue. The main issue is, since the police department no longer has a hold on these vehicles, the owners of the vehicles, in my mind, would have to give permission for these attorneys to go and search and inspect their vehicles, since there's no longer a law enforcement hold. That is an issue that I think may be present, Your Honor. So that's like a second issue, like who's going to pay for it? How is the parties going to go about getting the permission of these various car owners to inspect their cars? And let me see here. Oh, and just the logistics of in the original order, they had contemplated a situation where gosh, I apologize. The cars might have to be moved in order for the inspection of the vehicles to take place. And at the time, it was the police department would assist in the transportation of these vehicles for inspections. So that's another issue, is just the logistics of, since the police department no longer has a hold on these vehicles, the logistics of who is going to move these vehicles if needed. So anyway, that's the issue, Your Honor. This is basically, I just want to bring it to the court's attention to see if how it wanted to address this issue, Your Honor.
Okay,
Your Honor,
so, I see you, Ms. Piercy. I see you ready to chime in here, and I am going to ask for a bit. But let me make sure I understand, just because I'm looking I'm looking at the order. I understand what you're telling me, Mr. Martinez. Is there a corresponding pleading or request that I'm supposed to be looking at beyond that? So we just have this as a status. So I want to make sure I'm not missing something. Now, Ms. Piercy, have you and all the other attorneys been conferring about what sounds to me should be a new proposal, some agreed proposal on how to handle this, maybe in coordination with the city attorney?
Yes, Your Honor. And just as I'm sorry, I don't know. I think my volume was too loud. Is that okay now?
I heard you just fine. I don't know if
you did.
somebody else got freaked out, but I'm good.
So, Your Honor, there was a motion that we filed because what happened was all of the plaintiffs and interveners sent their experts out to El Paso to do the full inspection of these vehicles. We were told that we were going to have full access to the vehicles, to download the vehicles. And when our experts got there, that wasn't the case. They weren't allowed to download the vehicles.
What date was this?
This was back in, I believe it was in December. I believe it was December 12th or 14th or so. And so after, when we were told you can't download the vehicles, we filed a motion and we set it for a hearing. And that was when we were contacted by the city attorney to get an order put into place so that we didn't have to have that hearing. And so that's why we got the order that I believe your honor has in front of you.
Mm-hmm.
Now, after that time, we were working on scheduling the experts to go back out there to be able to download these vehicles. It was then brought to our client's attention on March 14th, I believe was the date, that these vehicles were being released and they needed to be picked up. I contacted the city attorney and said, hold on, there is a court order that the city has to hold these vehicles until we're able to get these inspections scheduled. And that's what the order states. And so that was when I was told, oh, we're going to have some kind of conference with the court, but no motion to reconsider has been filed. No motion to try to redo this order has been filed. And so my suggestion was, let's just go ahead, get all of our experts back out there, download these vehicles, and then everyone can do what they want with their vehicle. And I sent dates where my experts were available and was told by the city attorney, well, remember the order says they have to have 10 days notice before you can go inspect them. So what I asked everyone to do with the status conference today was bring dates that your experts could go out and download these vehicles so that we can move on and everybody can take their vehicle from the city now that the city supposedly doesn't have a hold on them. And so that was my suggestion to try to resolve this issue. And I brought dates that my experts are available. Admittedly, one of them is May 9th and 10th, that's not 10 days notice per the order. I assumed that the city was trying to get rid of these vehicles. They would waive that 10 days, but that's 8 days from now. I have May 20th through the 21st and June 5th and 6th that my experts are available.
Has everyone conferred? Is there some agreement as to those proposed dates?
I just told everyone it would be a good idea to have those dates available for their have dates for their experts when we came to this status conference today so we could set a date and get this handled and taken care of.
And I just want to make sure, Ms. Leal, are you here on this case as well?
Good morning, Judge. I am sitting in for Cindy Vasquez and Mitch Moss for Moss Legal. And yes, we are here on behalf of plaintiff Daniel Alamos. Yeah, I was sitting in the chat in the waiting room for a while, waiting for them to let me on. I apologize for being late.
No worries. There was a lot of folks that we did not have reflected on the docket, so our apologies as well.
Thank you, Judge.
Okay, so I mean, this isn't Is it that complicated? I mean, do you all have dates?
Well, Your Honor, if I may,
Uh-huh.
it's the order as it stands now says that the police department will assist in these vehicles and will attend any inspections of the vehicles.
Mm-hmm.
And that made sense before. It made total sense before because there was a law enforcement hold on these vehicles.
I understand that, but I don't have an alternative other than new dates. So do you have a proposal of how, I mean, there isn't a pleading, there isn't anything. We're just kind of brought all together by this request for a status conference that I understood was somewhat urgent, and I get it. But, you know, right now, I get it, the order is outdated, and I am hearing some proposed dates. I'd like to know if there's agreement on those proposed dates. I'd like to know if the city attorney, I mean, what you're telling me, this order is outdated. So does the 10 days notice matter? Do you still need that? If so, why? I mean, I don't have all those details.
Well, my concern is it would be, in my mind, unlawful for the El Paso Police Department to take part in any sort of inspection or search of these vehicles at this point, because they are no longer being held for law enforcement purposes, Your Honor. This.
Okay, well, let me ask you then, Mr. Martinez, why don't you file something?
Well, that's why I wanted to bring it to the court's attention. Just because I wanted to, I guess, just to get some guidance as to how you wanted to handle it. I want to bring it to your attention what I believe to be a situation where there could be potential liability. You know, that you know, these third parties go and inspect these vehicles, the owners haven't given permission, and the law enforcement is not taking part in these searches.
Everyone here, though, Judge, are the owners of those vehicles. And so they're going to participate. The owners of these vehicles' attorneys are going to participate in these inspections. If the police department doesn't want to participate, that's fine. We don't need them to be there to participate.
Yeah, you know, Your Honor, it's Victor Biganowski. They've had these vehicles for a long time. It's not like they haven't had access to them. We have not had access to them. Both of those dates suggested by Ms. Piercy are fine with my expert. I just checked. So if we can get an agreement on when we can go inspect these vehicles, I think that solves the problem. And if the city, I'm sorry.
Sure, Mr. Biganowski. I mean, I want to say yes. I want to say, okay, I agree, but that's not what I'm hearing from Mr. Martinez. I think what I'm hearing from you, Mr. Martinez, is that the city no longer wants to have these vehicles, right? So inspection, no inspection, where there's agreed date, you are releasing those vehicles and you want them gone. Is that what you're saying?
No, Your Honor, we have to be clear, the city owns this lot, so we have no problem holding onto the vehicles. We've held onto the vehicles in compliance with the court's order. Absolutely. I guess the issue then becomes taking part in any sort of inspection of these vehicles, right?
Okay, in what manner is the city taking part in these inspections? Is it allowing the experts on?
Well, as it stands now, as the order reads now, that the police department will kind of facilitate the search of these vehicles and be present while these vehicles are inspected and any sort of data is retrieved from these vehicles. That's the way it reads now, and that's what I'm saying is that doesn't jive now because the El Paso Police Department has no interest in these vehicles at this point.
Okay, so let me look at a little bit more closely at the order. So preserve, releasing, modifying, repairing, destroying any of the vehicles. Okay, 2, PD will work in good faith to allow the plaintiffs to inspect. Experts allow PD the ability to transport the vehicles.
Yeah, you know what's nice now, Your Honor? I apologize. All the vehicles are in one place. It would be awesome to do that inspection in one day of all the vehicles, and then we're done. We're done, and then our you
Exactly.
see,
And let me, I'm sorry, Mr. Biganowski, I really
that's
don't mean
okay, Your Honor. I'm sorry.
cutting you
I'm
off,
sorry.
but I'm reading and thinking, and if I don't say it, I'll forget it probably. So
Okay.
looking at this order, so, paragraph 3 says, data modules need to be removed. A certified mechanic from the city. I can see provisions in here that are no longer applicable. So for example, can't you all just come up with a new order that doesn't have so much responsibility on the city? And it basically says, while the vehicles are still there, we've agreed to these dates, and the city's only responsibility is to allow you to go in and do your inspection and leave. I mean, I'm being overly
That's a
simple.
great suggestion, Your Honor.
Yes,
Mr.
that is perfectly
Martinez,
fine with us.
just like you all drafted these specifics, can you not have just a much simpler order that says that they will be allowed to inspect? And even if you wanted to give it a cutoff date, right? A cutoff date of, plaintiffs have 30 days, or there's a date certain that it has to be done, and that's it. That's what we're going to accommodate. No?
No, I'm I guess my concern is I understand what they're saying, that each one of these 9 vehicles is owned by one of the parties to the litigation. And then they very well be so. I don't know. But I mean, if that's the case, then I guess if they, there's some sort of, it presents some sort of documentation. I understand one of the owners of the vehicles is dead. So I guess like some sort of representative from that individual in this.
Yes, I represent the estate. I represent his wife, who is the representative of his estate.
Right. So I guess that would be the thing, is that if they could just.
Mr. Martinez, there in that case, I mean, I could see where maybe a provision that states that this inspection will comply with all the city of El Paso's policies. So anyone who is a legit owner or party to a vehicle, that's who's going to be allowed in with their expert, I'm assuming, right?
Yes, Your Honor. You can order, Your Honor, you can order that all of the vehicles involved are able to be inspected by the parties and their representatives. And it doesn't matter what the owner of the vehicle says. So I think that that's the way to accomplish the concern.
Well, I also would like to be, I guess, respectful, right? Because the city is kind of, I don't want to put it in such kind of basic terms, but, as a courtesy, holding on or have these vehicles stored still on their property, that any activity be in compliance with whatever rules the city has about coming onto their property. But I mean, that seems pretty simple. I'm not kind of understanding what the holdup is.
No, that's great, Your Honor. Yeah, just some sort of documentation that either the owner or the owner's representative, great. That's perfect.
So can you knock out a new order in about a week and send it over?
Yes, Your Honor. I will draft a new order, circulate it to all of the parties. I can have it done by tomorrow and circulate it, and we will get it to the court by a week from today.
Okay. Mr. Biasa, you're pacing and you're making me nervous. Go ahead, Mr. Biganowski.
Ms. Piercy, and the dates you suggested so far are what again?
My experts have May 9th and 10th, May 20th and 21st, June 5th and 6th. So any of those dates will work, and I can put a date certain in the order if you guys will email me which of those dates will work for your experts.
Yeah, I think we should all do it today or tomorrow. It's not going to take long to figure that out. That's fine. Thank you, Ms. Piercy. Thank you.
Of course.
And just again, Your Honor, so as the owners of the vehicle, they understand that when they come to pick up these vehicles, they're going to have like these $2,000, $1,000 bills that have accumulated. I know it's like a sub issue. That's not the main issue, but that's just something to keep in mind, that there are storage fees,
Let me ask you something, Mr. Martinez. Is there any way you can get a figure for us Because it's really a property damage issue with the insurance company, whether it's the carrier for the client or Pantusa, and or the attorneys cover that. So if you could get us the figures, that would help.
I can tell you, as of today, each of the regular vehicles is $1,070.95. The Peterbilt truck, on the other hand, the bill as of today is $2,119.18.
Is there any way you could put a figure on what it would be in 30 days?
I can get that for you. Absolutely.
Thank you.
Because, you know, if our clients are going to have to incur another $1,000 to keep these vehicles here, when the order specifically says that that the city is supposed to be preserving them, I mean, we're going to have it.
I mean, that's why, I mean, if we're going to have an issue, Mr. Martinez, if I know you're calling it a sub issue, but this sub issue has already come up a couple of times today. You know, the order is still in place, right? So if you're going to be addressing the sub issue, then I need it to be, I mean, I understand they're asking for figures now, but if we're coming back here for anything like that, I better see something in a pleading, because the order's in place. I mean, I really would have thought, I can't even put a timetable to it, because I know there was this urgent request and how quickly we could get to the court. Quite frankly, I really think this could have been done on your own.
You know, and I apologize. You know, this issue of billing, when it at the end of January, it wasn't even on my radar at all, because this was in police custody. These vehicles.
I understand in January, but after, I got to assume it was after March 14th that the issue of these vehicles being on city property was a concern, because you were coming to the court asking for a status conference. Rather than waiting an additional month, you know, where fees are incurred, right, or are piling up, there really should have been, as soon as March 14th, we know that this is no longer part of a criminal investigation and City of El Paso has no intention of keeping or being held responsible, there should have been a new order. You should have requested that.
And Your Honor, this is the first time I'm hearing about storage fees that my clients have been incurring for the past, 6 weeks. I mean, when the order that is in place is that the city is to preserve these vehicles. And so if anybody is going to be asking us to pay $1,070 for a vehicle that has been supposed to have been preserved by the city per this order, we're going to have a problem with that. And I will fully brief it for your honor, but we're going to have an issue with paying that.
Yeah, I mean, I don't want to comment anymore, because the order is silent on anything with respect to fees. It's only on the responsibilities that the city signed off on, and there hasn't been a request to rescind that. We've only had a status conference. So I would encourage you to file something to include a new proposed order that you all agree on very soon.
Thank you, Anna.
Do we have a trial?
No, Judge, I was hoping we could get a trial date from Your Honor today and put together.
I think now is as good a time as any.
I agree.
Let's do a year out from today.
So Judge, you would like for us to put together a proposed schedule or an agreed scheduling order with 5.
We will send you. Let me tell you how it goes. Sorry.
Okay.
No, that's okay. And stuff. We're going to do May 9th. Ooh, Mother's Day week. May 9th is your jury trial setting, with May 7th as your docket call. The court will send you a proposed scheduling order for you all to circulate, sign, agree to a mediator, return it to the court within 2 weeks. Anything outside of those settings, request your hearing with a file stamp motion, and we'll get you a hearing anything outside of those dates.
Thank you so much, Your Honor. We appreciate it.
All righty. Anything else?
Just to be clear, Your Honor, that there will be no actions regarding these vehicles until a new order is put in place.
We have an order, and that's
Well,
taking care of it now until we have a new one.
okay.
Yeah, no action. I mean, I'm not doing anything. There's an order. You all are trying to square away what has changed since the last order. I mean, are you asking for relief for what? I mean, you haven't filed anything.
Well, that's why
I'm not sure, Mr. Martinez. I mean, it's not just like, hey, let's have a conversation. I mean, if you're asking for some type of relief, what I am understanding was discussed today is the need for a modification of that order, and I have tasked you all to go ahead and do that.
Yes, Your Honor, that's correct.
Okay. So if there's something else, file a pleading. We'll get it scheduled for a hearing. I will need the scheduling order back in 2 weeks. Otherwise, I'll need to see you at that entry hearing.
Thank you, Your Honor.
Thank you so much, Judge.
Thank you for your time. Y'all have a good day.
Thank you, Your Honor.
All right, who's next?
I have only one party for 2141, Judge, on page 4.
A little early.
Let me bring Miss Lauren Esparza to see if she's one of the parties. She hasn't answered any of my messages. Morning, Mrs. Esparza. Mrs. Esparza?
Hello, good morning. I'm sorry about that. I was
Good
having some
morning.
computer issues.
Which cause number are you here on, ma'am?
I am here for 2023 DCV 3903. I believe it was just a status conference.
3903. Oh, and it just finished.
Oh, oh my gosh.
I was trying to reach you through the message, sent you a chat to see what cause number you were here. You never answered, so.
For some reason, I got kicked out of the Zoom. I was in the meeting and then I was sent back to the waiting room.
Okay, no. So yeah, that cause number the judge just heard. So,
Okay. I mean, I think the only thing was that we were trying to set up inspections and that so
yeah, so I think they got reset for May 9th.
Okay.
Trial. So if you want to call our coordinator, she can give you more information.
Okay, thank you, sir.
And Mrs. Sparsa, this is the court reporter. Just for my records, who do you represent?
The intervener, Mr. Antonio Dominguez, and I'm with the Leon Law Firm.
Okay, thank you.
Thank you.
Thank you, ma'am. I'm gonna start. Judge,
Yes,
I think we're ready for the last case.
I'm ready.
On page 2,
Mhm.
Mr. Sawyer for 1994, he didn't log in. We tried calling his office. They're trying to find out. Nobody has an answer.
Mr. Alvarez, can you tell me if counsel on that cause number 1994, if they open notice of the hearing?
Yes, Judge, let me go ahead and take a look. And it's Ms.
Oh,
Alvarez.
sorry, Miss Alvarez.
Yes.
All right.
Nice to meet you. Sorry.
When we're
Give me one
done,
moment.
thank you. If you'll just send it to me in the chat, let's bring in the folks on the 11 o'clock because I'm gonna have to be out for a noon meeting.
That's answer.
Yes, ma'am.
All right, I think, is that everyone? No, Mr. Abraham.
Yeah, Mr. Abraham is with my office, Your Honor. He's just observing today.
I saw that. Thank you. Okay. Is
Your
everyone
Honor,
there?
good morning. This is Cindy Vasquez, Your Honor, on behalf of the plaintiffs. I believe I don't see him. We're waiting on Mr. Greg Suquette,
Oh.
who he's a counsel for the plaintiffs, Your Honor.
Mhm.
Logging on to tell them that, Mr. Sawyer, to the Zoom.
Mr. Moss, have you been in touch with him?
Hello, Your Honor. I think Cindy's spoken to him most recently, so I'm trying to reach out to him right now.
Okay.
Okay, sorry about that.
Mhm.
Good morning, Your Honor.
Good morning.
Court reporter. Just by way of introduction, I am Richie Casares. I work with Mr. Rincon. I will kind of be handling his exhibits for him. Thank you, ma'am.
Thank you, thank you. And anything that you intend to offer and admit, please email it to delee@epcounty.com.
Yes, ma'am.
Thank you.
I don't know what is going on. I just tried to call him. He knew about the hearing. We've talked about it. I don't know if there's been technical problems or an emergency. I know we have two motions or two things pending. Maybe we could keep moving forward with the other motion. I believe the summary judgment.
We can start. I was letting my staff know I'm hoping an hour is enough. And I have a commitment at noon, a meeting downstairs, so I did want to get started. If you all are ready to get started, I would like to do that. We can start with the summary judgment motion.
Okay.
All right, let's go ahead and call it Mr. Monares. And Mr. Monares, before I forget, because I will forget, on that other case with Mr. Sayer, we'll have to call that when we're done with this case, okay?
Yes, ma'am. They just called. They said they would be logging in, but okay.
Okay. All righty. Thank you.
Calling cause number 2022 DCV 2141, Hector Medrano and Rocio de la Fuente versus Maroon Shields and Cook Trucking Company Incorporated. May I have announcements, please?
Yes, Your Honor. Good morning. Cindy Vasquez and Mitch Moss for the plaintiffs, Hector Medrano and Rocio de la Fuente.
Your Honor, Carlos Rincon and Amado Montoya here for the defendants. I also have a colleague, Joseph Abraham, observing, and I'll be assisted by my assistant colleague, Richie Casares, with a few PowerPoint slides.
So let's go ahead and get started. Thank you. Good morning, everyone. Let's get started on that summary judgment. Mr. Rincon.
Your Honor, may it please the court, counsel, a no evidence motion for summary judgment relative to the direct causes of action against the truck company, Cook Trucking, for negligent hire, retention, supervision, and training of the driver, Mr. Shields, and the gross negligence allegation as to Cook Trucking and Mr. Shields has been filed in this case, Your Honor. The time for discovery has been completed, and so the motion is timely. In response to the no evidence motion for summary judgment, the plaintiffs only responded to, as I understand it, the negligent hire case. So by non-contravention, it would appear that the court would be well within its discretion to enter a partial summary judgment order on negligent retention, supervision, and training, and on the gross negligence causes of action in favor of the defendants. So today we're only here to speak to the negligent hire cause of action. And with respect to the negligent hire, and to put this into perspective, Your Honor, the plaintiffs, Mr. Medrano and Ms. De La Fuente, are still going to have their right to a jury trial, their day in court. They have sued Mr. Shields, a truck driver. He's formerly with Cook Trucking and Cook Trucking, who was the principal and had employed Mr. Shields to operate this tractor. And there's an allegation of negligence against Mr. Shields, and through the doctrine of respondeat superior, to the extent that Mr. Shields is found to be negligent and proximately causing this event, then there's vicarious liability. So the way this no evidence motion for summary judgment is framed, it's as a partial, because we're going to go to trial at the minimum on the direct negligence against Mr. Shields, who was in the course and scope with Cook Trucking. And this motion doesn't address that part of the case. On a no evidence motion for summary judgment, Your Honor, the way the rules write, when the parties have had ample opportunity to conduct discovery, you file a no evidence motion if there's no evidence on a required element of a particular cause of action. And here, despite the response and the evidence that was offered by the plaintiff, there remains no competent evidence to create any issue of fact, material or otherwise, that would prevent entry of summary judgment. And specifically, Your Honor, the plaintiffs, in response to our no evidence on negligent hire, referred to a series of inadmissible pieces of information that were exchanged in discovery. And we know that when something is discoverable, that doesn't make it admissible, it's just discoverable. And so what they have filed to attempt to create a fact issue on negligent hire are references to arrests in 2015 having to do with, if I'm recalling correctly, drug possession charges. And relative to other bad acts, criminal actions in a civil case under the Texas rules of civil evidence, basic rule must be within 10 years. It has to be either a felony conviction or a crime of moral turpitude and in a conviction. And there isn't that threshold made. So those other bad acts are not admissible and therefore cannot be competent evidence to refute a summary judgment. No evidence create a fact issue. The second piece of information was a citation that Mr. Shields had received for having non-compliant equipment, like an out-of-service order at some point in his driving history. Similarly, that other event doesn't involve any type of disqualifier for his license as a commercial truck driver under the Federal Motor Carrier Safety Administration. And it's an extraneous collateral matter that tends not to prove anything. It's not relevant to any issue in this case. Consequently, there is no evidence on the negligent hire issues. Summary judgment is proper. We filed objections to those pieces of evidence because standing alone, in order to use summary judgment evidence as evidence to create a fact issue, the evidence has to stand on its own merit, and it doesn't. In this case, it's inadmissible. So in view of that, Your Honor, there's no competent evidence to create a fact issue in response to summary judgment. The negligent hire cause of action goes away in our assessment, and this case will proceed only on the negligence, vicarious liability, respondeat superior prong of the liability case. Thank you.
Thank you. Ms. Vasquez, did I understand that you were responding to this?
Yes, Your Honor, I was responding. I'd just like to know, does the court want me to address Mr. Rincon's argument before the court rules on the objections or after? Because I think that's going to depend on, how much I have to say.
I will rule on the objections after, so go ahead.
Okay. Yeah, Your Honor. And we think that this is a directed verdict issue. We think that there is sufficient evidence to indicate that Cook Trucking did negligently hire Mr. Marone Shields. So when Mr. Marone Shields applied to become a driver for Cook Trucking, he did have some convictions he did have some arrests in his history. And as a motor carrier, Cook Trucking had the opportunity to look at that criminal record and evaluate it and choose whether or not to hire him. In fact, Cook Trucking did conduct an examination of his criminal record and his record in general, and did not find that there were any violations, although there had been some violations. The violation that Mr. Rincon referenced prior to his hiring, it wasn't until approximately 6 months later that Cook Trucking found out about the non-moving violation. And so we do think that there is a fact issue that would be more appropriately addressed at the directed verdict stage once the evidence has been made available to the jury, Your Honor, because we think that with the history of the citations that a jury would be inclined to find that Cook Trucking did negligently hire Mr. Shields.
Okay.
Your Honor, 30-second rebuttal, if I may.
Hold on a second. And I will hear it, Mr. Rincon, but Ms. Vasquez, with respect to the objections to that proffered evidence, what is your response?
With respect to the objections, Your Honor, I'll be candid with the court. They weren't filed until yesterday evening. I did not have a time to review them. I'm just going off of what Mr. Rincon stated during his argument right now. I didn't read them until this morning, Your Honor. Which is why I was asking. I don't know if the court was going to grant or deny the objections. I mean, Mr. Rincon is correct as to the negligent retention, supervision, and training. Obviously, we did not respond to that, as well as the gross negligence. It's just really the negligent hiring that's at issue right now.
Go ahead, Mr. Rincon.
Your Honor, briefly, the information about prior bad acts, none of it, there's no evidence, would impact the qualification of Mr. Shields to operate a commercial tractor. So there isn't any penalty under the Federal Motor Carrier Safety Regulations that would characterize these prior bad acts as what is known as a DOT disqualifier, something that would limit his ability to operate on the public roads. That would make it relevant, and that threshold wasn't made. But beyond that, even before you get to that relevance prong, you need to establish the independent admissibility of these prior bad acts, and there is no foundation. And we respectfully request the court enter summary judgment on the negligent hire cause of action. Thank you.
All right. Anything else? Anything else on the summary judgment?
No, Your Honor.
All right. I had not seen I understood at least the summary of what your objections were, Mr. Rincon, on the summary judgment evidence. I had not seen the pleading filed yesterday, so I was trying to review that now, and I am going to further review it. Are you all ready to go on the motion to exclude?
Yes, Your Honor.
Okay, all righty. All
And
right,
Your Honor, yeah.
go ahead, Mr. Rincon.
I know you have a hard stop, and I want to be brief because there's a lot of paper that was filed. We filed a motion that had a lengthy appendix, and then plaintiffs filed a lengthy response and with a lengthy appendix. And so I can imagine.
Let me ask, I think it was this one that I was, did it actually get filed?
Yes, we have a file stamp on the motion to exclude that we're arguing today on April 1st, 2024 at 3:50 p.m. And I believe the plaintiffs were filed on April 26, 2024 at 4:15 p.m.
That's right.
I know that sounds like a silly question,
No, not at all.
but I struggled yesterday. Let me see. See, here are exhibits filed on April 1st, right?
Yes, Your Honor.
And I have a notice of hearing on your motion to exclude, but I never found the motion to exclude as part of the entries in Odyssey.
Your Honor, if it would help, we could have hand-delivered our motion and the plaintiff's response and all of their exhibits in a binder would help.
No. We did find it in our email, but I didn't find it was in Odyssey. I usually go to Odyssey because I know when there's so many exhibits, what I'll do is usually I'll print out the pleading and then I'll use Odyssey. So I don't mind using paper, but it also takes all my toner. So let's get started.
Your Honor, and considering, I don't know, has Your Honor had an opportunity to review the briefing of the motion yet?
Yes, I have.
All right, so I will first state, this is Carlos Rincon on behalf of the movements. Cook Trucking Company Inc.'s motion to exclude Monica Cohen, who's a life care planner, Dr. Wilson Amante, who is a retained pathologist or a physiatrist working with Ms. Cohen, and then treating doctors Spencer Miller, Richard Newman, and Scott Auerbach. Your Honor, in a nutshell, the basis of our Daubert challenge is to exclude the medical causation opinions of these retained experts. Medical causation is the opinion that essentially attempts to correlate within a reasonable degree of medical probability the complained of injuries and setbacks that Mr. Medrano and Ms. De La Fuente suffered, allegedly, from this accident to the accident itself. Now, all of these folks are in the medical field. Ms. Cohen's a nurse, life care planner. The rest of them are MDs. But in that domain, whenever a medical professional is attempting to make the causal link, the causal connection, connect the dots between an event and injury, there must be a methodology. And I selected from a robust PowerPoint that Mr. Abraham prepared just a few of the slides to give Your Honor the benefit of background. These PowerPoint slides are not evidence. They are demonstratives. I'm not going to submit them to Your Honor. I don't think that'd be appropriate. But I would just go over them if Your Honor would permit me to briefly and succinctly get right to the meat of the coconut, because I intend to be brief.
Yes, sir.
Mr. Costavitz, can you share screen? Okay, so here is the framed motion, and I want Your Honor to consider that whenever a motion to exclude an expert is filed, certainly by me, and in this case that's the case, I'm not commenting on the character, all the subjective persona of the individual. The motion is directed, what I'm pinpointing now, and which is critical to be proven in advance of allowing these folks to testify, is that before they can get up in front of the jury and say, yep, this car wreck caused these injuries and thus the need for future medical care, there must be a demonstrated methodology. If we go to the first slide, and just because you're going to hear about it, and counsel will argue, this is the nature of what is going to be. This is the nature of what's going to be at issue before the case, and so low speed, low impact event. And we're not addressing this issue via biomechanics or occupant kinematics. That's not an issue. What we're addressing here is purely the medical causation opinion. And that's why we're here. Let's go to the next slide. So whenever a Dalbert challenge is filed under Rule 702, what then triggers is it shifts the burden to the plaintiffs. In this instance, that is the party that's proffering the expert to ensure that the gatekeeping requirements that Your Honor is going to require all of us to meet before experts give opinion are satisfied. So the burden of proof shifts to the plaintiff to demonstrate that these expert opinions on medical causation attributing this accident to the injuries and the need for future care satisfies Dalbert. For it to satisfy Dalbert, we go to the second one. It must be relevant and reliable. And that was actually on the previous slide, but it's in the brief, okay? The proponent of expert testimony bears the burden of demonstrating its relevance and reliability. That's the Gamble versus Jack Williams Chevrolet case. It's a very famous products liability case, Texas Supreme Court. And in that opinion, Your Honor, the Texas Supreme Court looked at the Dalbert opinion that was issued from the U.S. Supreme Court and transposed it to Texas practice. And it's been a cornerstone case in trial practice in Texas since the late 90s. It's certainly, a feature of all cases that go to trial in El Paso. Let's go to the next slide. So when you get to the question of medical causation, the way that it is to be demonstrated and proven by the plaintiff, that is the party with the burden of proof, is through a differential diagnosis. Now, there is a very good opinion, and I think there's a little typo on my case side. It's actually the BNSF, not the BNFS, Burlington Northern Santa Fe versus Nichols. Your Honor, that opinion does a very good job of explaining, in my opinion, the challenge that treating doctors, or really any doctor in a case, has in order to make the opinion that a certain event caused a certain ailment and the need for future care. And what it requires is this differential diagnosis. And what is it? Basically, what a medical doctor must demonstrate within a reasonable degree of medical probability is to rule in, consider globally all potential causes of the same symptoms, pain, limitation, what have you, or memory loss in this case. And then one by one, eliminate all potential causes that you ruled in, you got to rule them out. And to make the opinion that an event, this event that you've seen, caused both orthopedic injuries and the neurological cognitive losses that are being at issue in this case, there needs to be that causal opinion within a reasonable degree of medical probability. And one of the things, Your Honor, that we will learn in this trial, we go to the next slide, is differential diagnosis is a recognized standard for medical opinions. Now, I showed Your Honor that BNSF opinion. That's a good case to read because it's a railroad injury case where some railroad workers are claiming that due to the repetitiveness of getting on and off rolling stock, locomotives or train cars. They developed certain orthopedic musculoskeletal injuries, and the allegation was, did the railroad provide a safe workplace, and did their negligence cause the chronic condition? And you know, there's a lot of give and take, but they do a good job of talking about this issue. Then we said, okay, what does the El Paso Court of Appeals have to say about this? Well, the case that we cite here, I haven't read the TXI transportation case. That's a Texas Supreme Court case, but this is Candia Energy Operating Inc. case, and it's an El Paso Court of Appeals case. It's not, for court's reference, it's not a bodily injury case, but it is a case where some scientists, chemists, are talking about trying to pinpoint the cause of what I understand to be a oil well blowout or some problem with a well. And there are many potential credible causes for the problem. And the El Paso Court of Appeals said that to be relevant and reliable, the opinions, when you're trying to make that kind of scientific causation prong, you have to rule out credible causes. And the reason we have filed this motion, Your Honor, is that reference the opinions of these doctors linking this accident to the injuries, both orthopedic and cognitive, and then the need for future medical care, is the record is completely silent on anything remotely approaching a differential diagnosis. The only thing that these physicians and the life care planners speak to that could even knock on the door of what the requirements would be is something known as temporal association, which we know is not enough, and it's been discussed. Let's go to the next slide. So when I state to the court, and I'll represent to the court, there are a lot of medical records in this file, and they number in the thousands of pages, and there's radiology. But there isn't any opinions from any source, no treating doctor or no retained expert that goes through a methodology like a differential diagnosis to rule out other credible sources of issues that these two plaintiffs would experience given their age, given their activities of daily living, their work life, and their presentation clinically. There's no attempt by the plaintiff's expert presentation to rule out other credible causes. In fact, if you go through the records, other than cursory surface correlation, like Mr. Medrano comes in post-accident to complain of back pain, and there's a suggestion that as a result of that, he's going to need future life care needs. Well, that all assumes that it's first been demonstrated reliably that the injuries and the need for care have been demonstrated with a methodology to link the two up. And this record is silent on that. And, you know, one of the easy ways to handle these differential diagnoses is when plaintiff's counsel rebuts this argument, let's identify specifically where in this morass of information is there anything remotely approaching a differential diagnosis. And I'll submit to you, Your Honor, there is no basis, none, zero. And so consequently, the opinion to link this accident to the injuries to future care, it's not sustainable under Dalbert. It simply isn't, and particularly what's been echoed by the El Paso Court of Appeals, the Texas Supreme Court. And Dalbert, looking at these medical issues, has been, this law has been inflated in Texas jurisprudence for decades. Let's go to the next one. So one of the things that you will note, Your Honor, is many instances, and they did it here, is treating and retained medical experts. If you look at temporal proximity, it's in our brief, Your Honor, but temporal association is not enough to prove differential diagnosis medical causation within a reasonable degree of probability as required by Daubert. Temporal proximity is simply patient shows up and says, I didn't have memory loss before the accident. I have the accident. Now I have memory loss. Or I didn't have neck or back pain before the accident. I have the accident. Now I have neck and back pain. That by itself is not enough to establish differential diagnosis. There must be a record, a clinical record, whether it be from diagnostic images, whether it be from physical examination or some other source, to establish the pathway and the foundation for these causation opinions and the need for future medical care. And this record is completely silent. There is none, zero. Go to the next one.
Carlos, that's the end of the slides you pointed out.
Okay, that's it. So we can pull them down. So, Your Honor, in a nutshell, and I appreciate Your Honor's time, that's it. There is no evidence of differential diagnosis, reliable methodology to prove medical causation. It is not there. Now, what we might see down the road, and I don't know, there hasn't been any attempt to disclose any of this. And truthfully, Your Honor, there just isn't a basis for it. But we're only as good as the record we have to rely on. And on the record, and we're entitled to move on the record, there isn't a basis for that medical causation differential diagnosis. It's not there. So if the injury causation, medical causation piece of it cannot be established, then the life care planner, who is not a medical doctor, who's a nurse, who is putting numbers towards opinions of future medical care, and an economist who's putting dollar amounts to the projected needs, all of that assumes medical causation is established. It hasn't been established. The record demonstrates to that. It's the plaintiff's burden to show the court, prove before these experts testify on medical causation. And Your Honor, the record will not support it. They'll hint of temporal association, but we know from the Texas Supreme Court, a long history of cases, that's not enough. So with that, we rest on our briefing. We thank Your Honor for considering this motion.
Thank you, Mr. Rincon. Is it Mr. Soquet?
Okay. Yes, Your Honor. Soquet. Yes, Your Honor. The defendants would like to treat, this is really an issue of the experts' admissibility of their testimony here, and they'd like to treat the experts' testimony like a house of cards. By pulling one card out, the rest of the experts' testimony should also be excluded, and that's just not the way this standard works in this case. The defendants contend that our experts' opinions and medical causations are not admissible. They question the qualifications of our retained life care planner, of our pain management specialist, 2 neurologists, and a highly experienced therapist. The truth of the matter is, Your Honor, that medical experts are not required to rule out every conceivable cause to establish the probable cause of a condition. What they must demonstrate is that their conclusions are based on a reasonable degree of medical probability, which in this case, our non-retained experts and doctors have. And this standard was met. They provided detailed and reasonable analysis based on their medical data, on their clinical judgments. They used scientific methodologies. And so the defendant's motion seeks to unjustly prevent the court from hearing essential testimony that's critical for establishing that causation and for quantifying the requisite compensation due to the clients. The non-retained experts met the standard that's required for the admissibility of their testimony, which is that they must have the specialized knowledge, skills, and education. Their opinion must be scientific. It must be based on special knowledge, and the testimony must be helpful to the trier of fact. And in this case, our non-retained experts and experts have established that. Our life care planner is a certified occupational therapist. She's authored over 40 different life care plans. She bases her opinion off of certified, two board certified neurologists, one who's been a fellowship, has taken a leadership role in their own clinics. The pain specialist management doctor works at a spine injury clinic. He's also peer reviewed and he's published. They all meet the standards required for the admissibility of their testimony, Your Honor. And the biggest issue here is that the defendants haven't argued to limit the scope of their testimony. What they're arguing is to wholesale exclude all of it. And that's just not the standard in this case, or should be applied. And so this is why we request that the motion be denied. There's an opportunity for the jury to weigh the evidence of what the experts are testifying to. But this issue about admissibility, I think we feel that the doctors and the experts have already met that threshold based on their skills, their knowledge, and the scientific methodology that they use to come up with their opinions about the injuries and the care needed for our clients.
Your Honor, a 30-second rebuttal.
Yes, sir.
Your Honor, the response from the plaintiffs is silent as to a reliable methodology. We are not via Daubert challenging the medical diagnosis, like what they saw in the plaintiff's conditions. That's not the basis of the Daubert. The basis of the Daubert is that these medical professionals, as experienced as they are, never undertook the analysis to correlate this event, injury, medical injury, to the point within a reasonable degree of medical probability to say that it was as a result of this event. And because of that, their opinions regarding what they saw in these patients, quite frankly, if it's not tied into this accident, is irrelevant. The jury doesn't need to hear any of it. And their ergo, nor is the future projected life care plan estimates and their cost relevant, because the Daubert challenge is about causation. And that issue, quite frankly, Your Honor, was just simply not addressed in the response because there's no evidence to support it. So with that, we'll stand on our briefing and all the attachments.
Anything else, Mr. Souquet?
Yes, Your Honor. Again, the experts don't need to conclusively draw that causation. They need only to provide a plausible link between the cause and effect that's as perceived through some sort of reasonable medical certainty. And the experts are permitted to base their opinion on the facts and the data that was presented to them. And so they personally observed the medical records. In some cases, they've personally spoken with the clients. And so they're able to draw their inferences and not have to draw a conclusive causation link here. They can draw a plausible link between the cause and effect as perceived through the lens of a reasonable medical certainty. That's the standard that they've met.
I did have a quick question on the motion. Mr. Rincon, you referenced the economist, the Sudhindra, Abhay Sudhindra. That motion, there was a separate motion to exclude that was filed on April 16th. I saw it referenced in your slides. I heard it in your argument briefly.
Yes, Your Honor.
But I did not see a response. The plaintiff's response was only as to the Cohen, Almonte, Miller et al. Individuals. I didn't want to jump ahead. I didn't understand this to include the economist.
Your Honor, very briefly, the motion on the economist, the Daubert, it simply is, if there's no medical causation that's demonstrated, projected economic costs and the need in the future is irrelevant. Jury doesn't need to hear that testimony. And that is it. It's just an extension of what we've already argued. So I suspect the argument would be the same and maybe the response would be the same. But the record, Your Honor, of these experts that we're challenging, again, the work, the clinical exam, the diagnosis, prognosis, their review of medical charts, that's fine. The Daubert challenge is on allowing them to opine that this event medically caused the ailments and the conditions upon which the economic damage model is based. There is zero, Your Honor, zero evidence to support that medical causation prong. It's not a question of is the evidence sufficient or adequate. It's zero. There is none. So that's the basis of our Daubert, and we'll rest on our motion and the silence.
Just one, can I? What?
Yes, Mr. Suquet, go ahead.
I think, Your Honor, I think that goes to the weight of the testimony, not to the admissibility of the testimony. And so the jury will have an opportunity, and Mr. Rincon will have an opportunity to cross-examine the experts at trial and to criticize the weight of the testimony that they're providing. This is what Mr. Rincon is trying to do here, is not allow this testimony to be admitted. And so the non-retained and retained experts have met the standard for this the 702 rule on admissibility. If it's an issue of the weight of the evidence, that's what the jury's there for. They will get to make the judgment on that, and Mr. Rincon will have an opportunity to cross-examine each of the experts, each of the retained and non-retained experts.
Thank you. I'm going to go back to this separate motion to exclude. Mr. Suquet or Ms. Vasquez, are you all prepared to respond today to that one as well? Is it the same response, or I did not understand this motion to exclude to be part of today's hearing, but
right, Your Honor, we didn't. I don't think there was a notice of hearing as to the motion to exclude Dr. Hendra.
Yeah, so that one is separate and apart.
Yes.
I just wanted to make sure I know the slide referenced, Mr. Rincon, your slide referenced Sudhindra, but I'll leave that separate and apart. Okay, so I do obviously need to review and digest some of your arguments today and look at the objections as well. So I need a minute. I know that's not ideal because we're so close to our trial date, but I hope to have everything squared away by the end of the week.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you for your time. Is there anything else for today?
No, Your Honor.
No, Your Honor.
Thank you very
No,
much.
Your
Have a
Honor.
good day.
Yeah, bye-bye.
And we just need Mr. or whoever is going to be here. This is on page 2, is that right?
Page 2, Judge. I believe Mr. Lee is filling in for Mr. Brian Sawyer.
Sir, are you here on cause Neighborhood Federal Credit Union?
Yes, Your Honor.
Go ahead and call it, Mr. Monarez.
Calling cause number 2023 DCV 1994 Navy Federal Credit Union versus Enrique L. Dominguez. May I have announcements, please?
Good afternoon. This is Lee for the plaintiff, Navy Federal Credit Union.
All right, we're set for a status conference. This has been reset. 1, 2, wow, a lot. We had a default that was set back in October, and since then we've gone through status after status. I will note that it's 11:51. This hearing was set at 10:15 a.m. and the court had to make multiple efforts to contact counsel to appear. What is going on this case?
Sorry about that, Your Honor. So we actually made a settlement and we will going to file the non-suit. And I thought this case was already, well, we already filed the non-suit, but it turns out we haven't. So we'll get that sent out today, Your Honor.
Hey, I will look for it by end of day. Thank you.
Thank you. May I be excused?
You may. All right.
Thank you.
Is that everything for today?
That is it, Judge.
Thank you so much. Thank you, Ms. Alvarez.
Thank you, Judge. Have a good